Counsel, please enter your appearances.
Julie Nelson for Christina Gardner.
Welcome, Ms. Nelson.
Jill Coyle and Dave Reed, we're here on behalf of the appellee or petitioner in this case.
Ms. Coyle, Mr. Reed, welcome to our court. Ms. Nelson, how much time do you wish to reserve?
5 minutes, please.
Thank you. Let's start.
May it please the court, Julie Nelson for appellant Christina Gardner. This case is about the meaning and application of the fault statutes, Utah Code Section 30-3-5, 8, B, and C. We've argued first that the fault statutes are not appropriate here, and second, that if they are, the trial court abused its discretion in diminishing my client's alimony so much. I'd like to begin going directly to finding 5 of the trial court's ruling on page 728. The trial court writes, petitioner, this was one of the reasons for fault. The trial court writes, petitioner suspected another affair in 2013 and respondent admitted to an inappropriate relationship in 2016 that at the time of the filing of the petition for divorce had not yet become physical. This is not within the statutory scope of Section 8C. Subsection 1 specifically describes what is fault. It says engaging in sexual relations with a person other than the party's spouse. Now, someday there may be cases that litigate the margins of what that means, but skiing with someone else is not going to be in it, and suspecting that someone might have an affair in the future is not going to be in it.
But
the court didn't.
Sorry, go right ahead. But for that activity in 2007 and 2009, the court seems to me to be finding that, all right, there was a subsequent conduct that was not violative of the statute, but given the previous admitted history that would violate or would constitute sexual relations under the statute, that did substantially contribute to the breakup of the marriage.
I understand, but that goes to whether the affairs in 2007 and 2009 substantially contributed to the breakup of the marriage, and not whether the activity in 2016
I think it's a difficult issue. Do we parse out, do we just ask the question? Because clearly what the district court did is made 3 kinds of findings, right? Well, I said there was an affair in 2007, 2009, there was sexual conduct. In addition to that, while there wasn't evidence in the record, there was suspected activity in 2013. In addition, there was the quote-unquote inappropriate relationship in 2016. And taken together, those substantially led to the breakup of the marriage, finding there could be no other reasonable explanation. That seems to me essentially what the district court did.
I agree with you, that's what the district court did, but I also say that the legislature has cabined what we're talking about. And the legislature has said that fault is engaging in sexual relations with another person, and not other things, not concern that that may happen again. And so I think we actually do parse it out, and the legislative history confirms that they intended to cabin it to that. And I think there's a good reason for them cabining it to that, which is that if a person, let's identify the sexual conduct and let's talk about that, but let's not talk about what we're worried is coming down the road. Mr. Gardner was clear that he knew this was never physical, and even if he was concerned it was coming down the road, he said he thought that the man she was skiing with wanted to take it further, but it wasn't physical. It's hard to see that the fault statute could include both saying that she is at fault because she had sexual relations in 2007, 2009, and because she didn't have sexual relations in 2016. If we talk about being concerned that something's going to happen down the road, we're pulling in all kinds of things that the legislature has stayed away from.
Isn't it more of a, drawn an old kind of metaphor that that later conduct was pulling the scab off the wound?
Well, maybe, but I think then it's important to look at the scope of the marriage. So this now sort of turns to what the actual impact of the 2007, 2009 factors were, and the disintegration of this marriage.
Before you get into the specifics of that, and I want you to, is it your position that those 2 earlier admitted incidents played no role in the breakup of the marriage?
No.
Okay, so they played some role. So your argument, of course, is going to be not a substantial role.
That's right.
Okay, so before you present, before you address the facts, as I see you're going to do, help us out with what substantial means in this context.
Well, we don't have good case law on what substantial means. We have other cases in other arenas where substantial means a very significant impact. We have cases discussing fault from before the plain language here. Judge Billings in Riley versus Riley used the phrase "but for." Older cases at fault talk about it being the immediate cause. And I think that makes sense as an analysis. Now, I'm not suggesting that it needs to be tight in time, but I am suggesting that it needs to be substantially contributing to the breakup of the marriage.
It doesn't need to be the only cause,
Right,
right?
right.
Is it unfair to say that this admitted non-sexual relationship may have added weight to prior admitted incidences, that they might maybe still not reach the level of substantial in your mind, but contributed more significantly based on this conduct that does not qualify as fault under the statute?
Well, I think that that's an interesting question. And in another case, it could be true. But here it's not. Let's examine what happened. There's these affairs in 2007, 2009. They stay together, right? They work through it. They stay together for 5 years. He describes that period. His own testimony describes that period as there having been a lot of discontent among us. He describes how he wanted her to work and how he didn't like that he didn't think she was carrying her burden. She wasn't a good homemaker. All these things. And then, after that 5-year period, his counsel says to him, and so tell the court kind of the history behind you guys finally separating and when that happened. And he says, home became pretty hostile, maybe for the reasons he had described. Home became pretty hostile, and Christina decided that because of the hostile environment, she demanded that we separate. It was Chrissy who wanted out because home was hostile. It wasn't him who wanted out because of the affairs. This is long before the skiing incident.
So I think this is a strong argument, Ms. Nelson, and I find this to be a really close call, and I'm not at all sure that if I were the district judge that I would have ruled the way that the district judge ruled, but doesn't the district judge get a fair amount of deference here? And in particular, it seems to me that the best evidence going the other way, you've cited some of the evidence going your client's way, but the best evidence going the other way was a direct question asked of Mr. Gardner, what kind of fueled your guys' separation? And the answer was a reference to the infidelity and what he viewed to be an inappropriate relationship. And then sort of like Justice Simonis' point about ripping off the scab, he used the cliche of the final nail. He said the 2016 relationship was kind of the final nail. And isn't that enough to give a basis for a district court to make this determination that gets deference on appeal?
Well, I think the district court's obligated to not just pull 2 sentences out of the entire trial and to look at the narrative of what's going on here. And the narrative includes his description. He goes on to say that it was Chrissy who demanded it, and his counsel asks him, so during this period, this separation period, they were separated for 16 months. She says, during this period, prior to the ski accident, were you under the impression you guys were going to get a divorce? And he says, yes. That's on page 1089. So I think as far as the entire narrative goes, it may be that this non-sexual relationship was the thing that made them say, okay, you're right, this is not going to work out. This ski incident was not going to work out. But the ski incident is not fault, and the 2009 affairs did not substantially contribute to the breakup of the marriage by his own testimony.
The problem is we don't have a determination by the district court that the 2007 and 2009 events by themselves substantially contributed to the breakup.
No, and my position is that on the basis of this record, you couldn't have that.
Well, wait, maybe not, but I'm saying it seems to me that didn't happen. The trial court conflates a bunch of things, puts them together, and says that's the basis for that's what substantially contributed to the breakup of the marriage. And maybe that's appropriate, maybe it's not. So that's, to me, a difficult issue under the statute. But we certainly don't have the former, and in terms of the amount of deference that we owe, doesn't it turn on kind of the quality of the factual findings that we have? I mean, we've got 3 or 4 sentences here.
Well, if we extract finding 5, as we all agree it's not sexual relations, and we're left with finding 4, which is that the 2007-2009 substantially contributed, I think that the findings simply don't support that. I don't think that we
have a finding, really no other reasonable explanation. But there's no analysis of that. There's no analysis of the 16 months apart and why that wouldn't be. There's a single sentence that says verbal abuse and an act of physical abuse isn't enough. And I guess that troubles me independently, but
You're right, and the court says there's no other explanation for them separating, with no analysis of all these other descriptions of problems in the marriage and the fact that it was Chrissy who wanted out because she thought the home was too hostile. That's not in the findings. I agree with
set
that.
back down. I mean, there's a possibility here that this gets set back down and just said, the findings, the district court, you haven't shown us the math. That maybe it's possible on this record with the district court could issue the kind of findings that we could review and afford the kind of discretion that Justice Lee referred to. But I'm wondering if it's appropriate for us to do that on the skinny findings here.
My concern is the language of 8C. 8C says engaging in sexual relations. And so we would have to ask them to isolate themselves to sexual relations. If the legislature meant sexual relations and other things that make you uncomfortable, it could have said that. But it didn't.
What about finding 3, respondent's infidelity substantially contributed to the breakup of marriage? Is that not a clear enough finding?
Well, and so my answer to that would be that that's not supported by the evidence of the record. That if we're limited there to the 2007-2009 finding, that's not supported by the evidence.
But that is a finding directly on
that
point,
is,
right?
That is. So that may eliminate a remand for that, to just do that.
So I wanted to ask you about, in the decree, the court lists the 2 ways that fault impacted the alimony payments.
Yes.
The second one is the length of the payment.
Yes.
And I wanted to ask you about that first. So the length of the marriage is really a ceiling on the alimony payment, isn't it? No one is really
That's right.
entitled to have that. So is this a deviation from a norm, or he just didn't give her the maximum allowed?
Neither. As we explained in our brief, 10 years is not per se an abuse of discretion. And in fact, neither is a step down. But the case law is clear that the recipient needs to be able to meet her own needs. And with the 10 years and the step down, the case law would ask whether there's a reasonable way for her to close the gap. That's the phrase. Is there a way for her to close the gap with that limit? And there's no analysis here that she would be able to. And in fact, the suggestions don't make sense. The suggestions are that she go back to work, although he acknowledges that she can only earn $1,300. He imputes her $1,300 a month and agrees that she can't work full time and that she doesn't have a great earning capacity, and that she could go to school, but he doesn't provide her with the money to do that. And as his backup plan, he suggests that she could go on government or charity, I can't remember the words now.
Disability payments.
The disability payments,
Could
right.
I ask you about something about the statutory scheme and how it works that I think goes to this line of argument that you're making here? It's not clear to me. So there's these statements in prior precedent along the lines of, fault can't be used for, punitive purposes. I mean, I think that probably doesn't survive the statute, right? Because the statute now says you can consider fault in deciding whether and to what extent to award alimony.
Can I address that before you?
Yeah.
You said A. Can I address that?
Of course.
All
That's
right.
fair.
So I would point you to McDonald that was issued just last week, where this court said, in analyzing a different subsection of the same statute, this court described that statute as being underdeterminate because it answered some questions, but not all of the questions. And I would say that that's exactly what's happened here. We have at-fault cases from before the at-fault statutes. We have decades of Court of Appeals cases. So I would point you particularly to Roberts versus Roberts, which was issued only in 2014. I think like paragraphs 46 to 48 describe this in great detail.
I mean, I actually agree that it's underdeterminate, and I think this might go to my part B of my question. Okay. Would you mind if I interject it here? Because I think it might short-circuit this to some degree. I mean, to me, it sort of begs the question to say, well, it can be used to decide, whether to award alimony. I'm not sure that necessarily means that you can, that all bets are off, and district courts get to do whatever they want. Not all fault is created equal.
Right.
There've got to be levels of fault. My part B of my question is this. How do we balance two things in the statutory scheme? On the one hand, the statute says these are the things that you shall consider, all the economic stuff. And then here's something that you may consider, which is fault. How do we balance those against each other? And in balancing them, should it be some sort of notion of there are different levels of fault. There's really egregious fault, and then there's kind of maybe minor fault. Is that a way to do it?
I think we should start with the fact that alimony, the trial courts have a lot of discretion, but alimony has this background of being a formula or an equation. We know that subsection 8A has these 7 factors that must be considered. And those 8A factors have to be considered in light of 8E, which talks about the marital standard of living, and only gives the judge the discretion to choose between the marital standard of living or the standard of living at the time of trial. It doesn't anywhere give the judge to just make up a new standard of living or a reasonable standard of living. And 8A and 8E are both mandatory factors. The trial court shall consider that. And all of our background case law explains not only that it can't be punitive, but that the primary purpose of alimony is economic, and that it's supposed to keep people at the marital standard of living, and it's supposed to equalize, and it's supposed to make sure that the recipient doesn't become a public charge. And I think that given this language in McDonald, where this court said when a rule is not in full, what remains is to be governed by pre-existing law unamended, I think all that background stays in place. So we get a formula, and the trial court has to do 8A, they have to do 8E, they have to keep these principles, and that gives them a range.
But
And
at least
within the
sometimes,
range,
would
they
it
can
not be
choose.
the right way to read the statute to say that at least sometimes with respect to what the judge might perceive to be really egregious fault, that a judge gets to decide? I mean, the statute specifically says in deciding whether to award alimony. So at least sometimes, I assume that has to sometimes apply, and that means sometimes it can be imposed punitively for a judge to say, I'm not going to award any alimony here because you, and it wouldn't be this case.
No, it
but
would be
you-
a case where someone had another spouse and child in another state, like in Riley.
Right, but so I'm not asking about this case, but
Right.
doesn't that suggest that at least sometimes it may be employed punitively?
Well,
Because doesn't whether to award alimony sort of punishment for fault?
so the word whether is interesting, I agree. The Court of Appeals often uses the word whether in describing a normal alimony case, whether to award alimony. And that makes sense because there are some cases where they may decide not to award alimony at all, maybe because the recipient or potential recipient actually makes enough money to support herself, or she didn't provide enough financial documentation, or there could be times when it would be in the judge's discretion to decide not to award alimony. So I think that that word whether is being pulled in from those Court of Appeals cases. It's not clear to me that that statute, that language says you can override 8A, 8E, and all of our background rules to say, no alimony, it's fine, put them on the public charge, put them on the public dole. It's not clear to me that, 8B is a may factor, whereas all the others are mandatory factors. And so my position would still be that alimony is this formula. 8A goes into it, 8E goes into it, these background things go into it, and you get a range. And once you're inside that range, then the trial court can choose. And if because of the fault, the trial court wants to go down a little bit, that might be acceptable. Now, I agree, balance is the right word. You know, the Court of Appeals cases have talked for a long time about this tension, and I think balance is the solution to the tension.
So counsel, so on this question of imputed income,
Yes.
you're starting down that path, and you argue that the imputation of full-time minimum wage was incorrect.
Well, I argue that $1,300 isn't full-time minimum wage.
Isn't that full-time federal minimum wage, 40 hours a week?
No, that's at $750, as they pointed out in their response brief, and full-time minimum wage is $725. So,
So it's undervalued by how much?
it's overvalued by,
Overvalued.
they said $43, not including payroll taxes. But I think the bigger point is that the trial court's analysis doesn't follow the proper structure. The trial court, when they're imputing income, a trial court is supposed to say, I think you can make this much, and here's how I'm going to figure it out. And it just kind of became arbitrary here.
Well, the court said, now he acknowledged she was working part-time, right?
Well, she wasn't working part-time. She said she could work
She said
15
she was
hours.
capable of working part-time. The trial court suggested that she had not presented evidence of disability, or at least adequately done so. Do you take issue with that?
Oh, I think that the trial court said, actually, that, that because of her medical conditions, she wasn't able to work full-time right now. I think it acknowledged that, and it would take me a second to find that.
Did she present evidence as to the anticipated tenure of that disability?
No, and neither did the husband call a vocational expert, which would be the ordinary way of supporting an imputation.
Did she seek some allotment for educational
She did.
expenses?
She did. She requested $600 a month for educational expenses, and the trial court eliminated that.
And I take it the trial court, and correct me if I'm wrong on this, felt that she did not give adequate detail as to, or any suggestion as to what kinds of educational
That may be
costs she might
true, but it
incur, what she
suggested
might
that in
receive,
order
or
for
so
her to
forth.
close the gap, she get some education. So perhaps it didn't care. She only has a high school diploma, so
Right.
perhaps it was left open to her.
It doesn't seem like the court believed that she could never work.
That may be right. And my argument on the imputation is simply that the analysis was somewhat arbitrary, and it's not moored in the requirements of an imputation analysis. I think a bigger problem is the taxes and the failure to include that.
Can you
How long- Go ahead.
No, go
I'm
ahead.
out of
You
time.
go
Should
ahead.
I? Go-
Yeah,
I'll
I
keep
see.
going.
I'll let all parties know that our policy is that as long as you're still asking questions, of course we are, as long as we're asking questions, you can continue. You need not seek
Thank you.
permission, and we're still actively engaged. So, Justice Peterson, did you
You
have
can finish yours.
a question? Well, it also relates to the, well, this relates to the public charge issue. You, I get, at least suggested that it was inappropriate for the judge to suggest that she may be able to go on disability because that defeats that objective of the statute, which is to avoid that result, right?
Right.
And is it your view that any governmental assistance would qualify as, to make someone a public charge? Any kind of governmental assistance, if they have to resort to any kind of governmental assistance?
I think when that's the instruction. Now, I have seen cases where a person receives government benefits, and that's taken into consideration as their ability to meet their own needs.
Is someone a public charge if they're on disability under the intention of the statute or the ordinary meaning of the statute?
Well, I think that the appropriate way to have handled that would have been to analyze whether she was receiving government benefits and whether she was able and entitled to receive government benefits. Her position was that she wasn't able to receive disability benefits because she had never
I'm not really speaking
worked.
to that. I'm speaking to the language in the statute.
I mean, I guess my
Provides
answer,
one purpose of the statute is to prevent a spouse from becoming a public charge. And I'm wondering if someone who seeks disability benefits qualifies as a public charge under the meaning of the statute.
I guess
independent of the facts.
I guess I would say not automatically if it goes to their ability to meet their own needs, and they in fact are doing that. It may certainly be appropriate in a petition to modify when a person is able to meet their own needs because they've gone on disability, then the alimony award may appropriately be diminished. But here, he's invited her to become a government or charity charge, which I think definitely suggests he doesn't have something specific in mind, but just generally, if she can't close the gap, she can.
I want to be stubborn and take you back to where I started. Do you agree that at a minimum, but for the affairs in 2007 and 2009, let me rephrase that. Do you agree the trial court found that at a minimum, but for the affairs in 2000 and 2009, 2007, 2009, the divorce would not have happened?
Not but for, no. You changed the words but for. The trial court found that respondent's infidelity substantially contributed to the breakup of the marriage, and my position is that the trial court certainly did not find that but for those, it would have broken up the
That
marriage.
seems like a stretch to me. I mean, it's the respondent had affairs involving sexual relations with others in 2007 and 2009. I mean, I give you that he did make the other add-ons, but they're in the nature of reminding the spouse of those affairs and creating a suspicion that that conduct was going to reoccur. I'm just saying, isn't that what Judge Bates found?
Well, the exact language is substantially contributed,
Well,
not
yeah.
but for. So I agree that I agree that finding 3 says what it says.
Not 343?
I'm looking at finding 3 on page 728. In this case, respondent's infidelity substantially contributed to the
Yeah, I'm
breakup
looking
of
at finding 43. It's on page 11 of the findings and conclusions. Respondent's infidelity substantially contributed to the breakup of the marriage.
That's the same
relationship.
wording.
Yeah.
So, back to also an earlier question then. Would you object to assigning a definition to substantial cause, assigning the definition of contributed in significant portion? Is that, in your mind,
I'm not sure that
too
it's
high a bar? Or I'm looking, you addressed earlier somewhat what a reasonable interpretation of substantially contributed would be.
right.
I'm looking to find that sweet spot that
Right.
you would agree would be a fair definition of
Right.
substantially contributed.
Right. I'm concerned that when we talk about something that's happened in the past, that we give somebody an ace in the hole or a king's X that says, well, this bad thing happened, we're going to work through it, but if we ever get divorced, I'll pull it up so that we
Yeah,
can't
I
use
understand
alimony.
that practical concern. I guess I'm just wondering, in writing this opinion, how we would describe what rises to the level of a substantial contribution.
Right, and
as a general matter.
right. And we may look to those old cases that talk about somebody leaving a spouse for someone else and say that it needs to be that high of a standard.
The flip side of your argument, though, is you're incentivizing people not to try to work it out, right? Because let's say the affair happens and it's bothersome, and the couple continues to try to work through it and work through it and work through it and work through it, and ultimately just can't. So it really does, you say, substantially contributed to the breakup of the marriage. And you want to say, well, that gives them a king's X. On the other hand, you're trying to create an incentive where if they try to work it out, they're penalized. What they need to do is hurry and divorce quickly then.
Well, I would like to add a competing consideration, which is that let's assume let's take the facts of this case, or a generic facts of this case. You have the wife who has not worked for years, and the husband has provided, and the wife is the one who's committed the wrongful conduct. Now, going forward, maybe she'd be better off to have it be divorced at that point so that she can start working. And I also think it's important to say that whatever happens here for the recipient is going to happen on the corollary for the payor.
What evidence was there about Ms. Gardner's ability to work going forward?
The husband had not called a vocational expert. The wife explained that she had worked a little bit on and off over the course of the marriage, that she didn't have any education beyond a high school diploma, that she'd made the number $11 an hour is sticking in my mind, and that was it.
It seems that often when a person is able-bodied and there's no reason that they can't work, at a minimum, a district court will impute minimum wage.
I agree. But she wasn't able-bodied. That was a factor. She had explained that due to all of these medical conditions, she wasn't able to work now, and that may change. And like I said, I do think that the court said that based on her medical condition right now, she's not able to work full-time.
And was there, I guess we've asked this question, what was the evidence about how long that her disability would prevent her from being able to work? Was this something that forever she's just not going to be able to hold down a job, or that could be overcome?
I don't remember the evidence on this. I know that the discussion of the injuries was quite severe. She explained that she can't drive until several hours after she's taken her medicine. There was a long discussion of how severe the injuries are, at least at this point. And I would suggest that perhaps when she's able to work, that would be appropriate for a petition to modify, or that the trial court needed to accept that as part of the rehabilitative alimony, but still make sure that, in fact, she would be able to close that gap over time and not just assume that she will be able to.
Because his findings do seem to assume that at the end of this 10 years, she should be able to be contributing by working. Was there any evidence that supported that, or do you think that there's just not evidence supporting the court's assumption?
No, I think we're looking at the overall analysis. The amount that she's being given right now, dropping her standard of living, the 10 years, and the step down. Is that going to be able to help her stay at her marital standard of living, which I believe is the goal even when fault is in place.
On that point, you seemed earlier to suggest that the lodestar or the gold standard is, or the statutory mandate is to, if possible, provide her the same standard of living.
Right.
And you
That's right.
suggested maybe some variance in the event there is fault, statutory fault, which of course you argue against. But you suggested that some reduction would be appropriate, if I'm remembering it correctly. Is that
I
right?
suggested that the formula produces a range, and that could be a place where the
Well,
trial
is
court
it-
could
the
choose between.
formula, yeah, I guess, yeah, I can see your point. So how would we define that range?
Well, I think that the floor is the standard of living. All of the statute.
Well, that's back to where I started then. Okay, so if that's where you get to is standard of living, is it your position that based on legitimate fault, a district court judge could reduce her income below that standard of living?
No.
Not at all.
No, I would say that that was the floor.
Okay.
I guess in the decree, it's the 13th page of the decree, where the court, you pointed out that the court said one of the impacts of the fault would be the court does not need to equalize the standards of living in this case, and that's not really applicable. That's when there's not enough money to go around.
We never
But-
got to the discussion of whether there was enough money to go around.
Yeah, so I think what later it seems that the court meant is not that he doesn't need to equalize the standards of living, but that because of the fault, he's not going to keep her at the standard of living of the marriage. It seems
He's-
like that's what he actually
Yes,
did.
and he said that during his oral ruling at page 1186. He said, I'm not going to give her support payments and find that she's entitled to expenses that afford her the same affluent lifestyle that she had during the course of the marriage. And he goes on in that section, page 1186, 87, 88, saying that because of her fault, she has to live in a less fancy house and drive a less fancy car, and she can't live in Olympus Cove anymore, which is where her kids go to school. She's
Okay,
going
so let's assume that's true, that even where there is fault, a judge can't reduce below the standard of living.
Yes, and I would say that the corollary to that is that where it's the payor that's is doing the fault, they can't go above his ability to pay.
All right, so what's the consequence of fault then?
Well,
The
it's
permissible
narrow.
consequence of force.
It's
of
narrow.
fault. Well, what is it?
It's-
I mean, you can't go below the standard of living. You have to give the standard of living regardless.
Right.
Right?
Right,
And so what area does that work?
right. Well, so we know that alimony produces a range of, gives a lot of
You might
discretion.
not get the top.
Right,
If there'd been no fault at all,
right.
he could have just said, he still could have just said standard of living, right? In fact, he was
If there had been no
obligated
fault at all,
to
he
do
would have been
so.
obligated to say
He
there's
was
the standard
obligated
of
to
living.
do so.
That's right.
Right? So-
That's right. But the standard of living is one of the 7 factors in 8A, right? And so the other factors in 8A may also be discretionary, the length
But
of the marriage.
regardless of those factors, he can't go below standard of living.
That's right. But he may be able to reach that from multiple ways, or he may decide the length of the alimony. He may decide a rehabilitative component. There are other things that are inside the judge's discretion. But the standard of living, I think the statute makes clear the standard of living is not inside the judge's discretion.
I just had one last question on the evidence. Is it possible that the judge, was there a dispute about whether she was actually paying rent, that her father owns the home where she's living, and so could the judge have thought, what's
He
the
never
evidence
said
on
that. He never said that, and we have recent case law explaining that even if a person, say, moved into their parents' basement, having help from your parents while you're working through this transition period, you're still entitled to a housing allotment. And that was certainly not part of the basis for his ruling. It absolutely was not. He said she only gets $1,600 and she can move to the west side of the freeway. Those were his words.
All right, thank you.
Thank you.
Thank you, Ms. Nelson. Ms. Coyle?
Well, this may sound like a particularly dumb question, but the finding that I have at 43 is respondent's infidelity. The judge didn't actually use the language of the statute. And does infidelity necessarily always mean sexual relations?
I believe, no.
And that's a problem I'm having, because in the subsequent paragraphs, he seems to be talking about sexual relations, about suspected inappropriate conduct and inappropriate conduct. And I mean, in fairness, he seems to be kind of mushing them all together so that there's not a specific finding of the 2007 and 2009 activity, that those sexual relations versus kind of this whole amalgam of factors leading to the breakup of the marriage. And I'm not questioning whether a judge could reach that conclusion, but I'm wondering if on the basis of these findings, we don't need to send this back down and have the judge tell us what he meant. Did he mean that based on 2007 and 2009, those sexual relations, that substantially contributed to the breakup of the marriage?
I think 43 might get you to that opinion, but if you read finding 44 and finding 45,
Have all of them.
you're going to get it. And you're going to get exactly the reasoning and the findings that he found that says that
You think it's enough?
it's enough.
Okay.
It's enough.
Can I ask you about a different one? Or I don't want.
I was going to follow up for 1 second, and that is, I know this isn't part of the findings, but it's what he actually said at the time that may help us interpret what he meant by the findings. And it's at page 17 of the transcript of the hearing.
Okay.
And I guess there's some question as to whether that really was a substantial cause of the breakup of the marriage. And that's talking about the infidelity in this case, 2007, 2009. I find that it was in part largely based on testimony from Mr. Gardner yesterday that he suspected another affair in 2013. Mm-hmm. So again, he seems to be, it's less about maybe 2007, 2009 than about, as I put it, ripping the scab off.
Yes. I think what the court needs to stop is we can't go outside and do the what-if scenarios. What we have to do is stay within the confines of what the statute means. This statute, when the legislation defined it after Roberts v. Roberts came out, it says specifically, if the court finds the wrongful conduct of one of the parties substantially contributed
But
to...
wrongful conduct meaning sexual relations, and he actually doesn't do that.
Actually, I would disagree in the fact that when he puts the finding of Rule 44, he says the respondent had affairs involving sexual relations with persons other than their spouse in 2007 and 2009.
I think this is where my question comes
Yeah,
in.
please.
I think Justice Simonis and I are looking at different documents. I'm looking at the decree of divorce, which is Exhibit B to the appellant's brief, and maybe there's a separate document called Findings and Conclusions or something that Justice Simonis is looking at, but just to orient you, that's what I'm looking at.
Okay.
And finding number 8 on page, Bates 729 and 13 of 18 is what it says at the bottom. It says, based on the evidence before the court and lack of any other reasonable explanation as to why the party's marriage fell apart, the court found that Ms. Gardner's sexual relationships with persons other than petitioner substantially caused the breakup of the marriage relationship.
Correct.
That does seem to address Justice Simonis's valid question about whether infidelity is the same thing as a sexual relationship, but this one says sexual relationships.
Right. And that's where I... Oh,
Well, I do think Justice Simonis has raised an important question. I think that it could be argued that the articulation just made by Justice Lee is supported also by paragraph on 728 of the record, paragraphs 2, 3, 4, and 5, where the court seems to distinguish between the wrongful conduct violative of 30-3-5, etc., that is sexual relations, substantially contribute to the breakup of the marriage. Then he goes on to refer to infidelity in 3, which seems to reference 2007, 2009, and he treats in 5 separately this suspected another affair. And so he's well aware there were no sexual relations as to that affair. And put that together with what paragraph 8, as Justice Lee has indicated, I'm not sure, at least to me, that there's a serious question about whether he impermissibly, or at least I shouldn't say it that way. I think perhaps the better argument is that he did treat them separately and was cognizant of the fact that only 2 of those incidents fell within the terms of the statute.
yes. And the thing is about the sexual relations statute, where it actually defines what sexual relations is in the statute, is that it specifically does not give a timeline. And I think it goes to your point that you made with counsel, is the fact is if somebody has an affair and then they try to work it out and then there's a suspected affair, he has to or she has to wait until there's proof of an actual sexual relations to leave that person. I think that that's that's where we're here today.
It's a
Is that-
problem. It's a bad incentive to encourage people to jump out early. I get that. And the findings and the decree, they do mirror, right? We just need to add a 4 in front of the 3, 4, 5, 6, 7, and 8. I get that. And 8, though, he also talks about the lack of any other reasonable explanation, but there's no homework. Again, he's not showing us the math at all. And I mean, really, how about the fact that they've been separated for 16 months? Is that not another reasonable explanation? How about the fact that there's a lot of testimony in the record that he was really unhappy with her, perhaps rightfully so, for a large number of reasons. And then his, I don't know how to characterize it other than odd, this notion that verbal abuse and a single act of physical abuse is not enough. Really?
Well, I think the evidence that was presented at trial lacked a little bit of credibility to that.
But
And
he didn't say
find-
that. He didn't say that. He said in his experience, right? He adds the word mutual verbal abuse in the finding, but when he's speaking from the bench, he doesn't. He said, my experience, verbal abuse and a single act of physical abuse, that doesn't lead to the dissolution of marriages. Really?
I agree with you that, and that's why in family law cases, not only is fault listed, but irreconcilable differences was listed
All I'm
as
saying
well.
is there's none of the math is shown. He's doing a reduction here. Well, I don't find any other reasonable explanation, but he doesn't tell us, except for the one instance, what those other possible reasonable explanations are. And I get giving a lot of deference to the trial court, having spent many, many, many years on the trial court.
Correct.
But don't you have to show us a little bit of the math? Is this enough?
I believe it is. I believe, and I think that it's important to know that the lower court did not make a ruling from the bench. He took it under advisement. We came back the next day. It was a methodical finding. It was specific. He had thought about it. It was not something that just came out of it, and then we had to go and rewrite the. And then when we did the proposed findings, there was a lot of discord with opposing counsel about the language.
There's a lot of back and forth.
And Judge Bates, or the lower court, he actually took the findings and he made language to make sure that it was very, very clear.
Along with Justice Simonis, I don't get this comment that there's no other explanation, especially because he goes on to say that, does he not suggest that, yeah, there were a lot of other things going on contributing?
Mm-hmm.
There's squabbling, there was the incident of physical, he acknowledges all that, right? Does he not?
Yes.
Suggest that those were factors, and so then the question becomes, I'll put it to you as well, okay then, let's assume there are multiple factors. Let's assume that all of those other things were contributing factors. How do we define what constitutes a substantial cause?
Correct. And I think that's where the court has the discretion to find it. And I think Judge Bates
I'm not talking about discretion. I'm talking about a legal standard. Okay?
What does it mean?
Yeah.
There could be a range of definitions. It could be contributed in some significant measure. It could be the predominant cause. It could be a substantial cause in this context. We can look at tort law maybe for help. But in this context, how would you articulate the definition of substantial cause?
I think when you look at the fault statute and you look that there's a limited amount of issues that can be considered fault, I think it limits it there. So we can look at substantially contributed. It has to fall within the 5 faults.
What does the word substantial mean, though? I think is what the Chief Justice is trying to get at. Is it 10%, 30%? Is it more than half? How are we supposed to understand the term and instruct district courts to apply it?
I think that's a great question because we've done a lot of research in the family law section, especially about substantial change in circumstances. What does that word mean? And there's not a lot of breadth in the case law to help us explain it. Today might answer that question. I think the facts and the finding and the discretion of the court was that he found that the affair, the infidelity, was the substantial contributing factor to the divorce.
So maybe we will use this case. So let's hear your definition. Recognizing that there's not a lot out there the courts have done, what would you propose to us be the definition of substantial in this context?
As simple as it was the main cause of the divorce.
Okay, well main cause, you could certainly argue for a lesser standard.
But
if it's main cause,
It's not the move I would have made if
might
I
make
were
a
you.
real, that might make a real difference here.
Right. Well, my thing is if you take all the causes, we all know that divorces are not simple, plain things that we go into court and we say there's one reason why we're getting divorced. There's usually years or things that
Right.
have attributed up to it. So what I'm suggesting, though, is that in the fault statute, he had to found that there was a sexual affair, infidelity that happened that was substantially contributed to the breakup of the marriage. He found that. That's what I'm suggesting. Everybody comes into court and says, oh, there was this and there was this, but that's what he found.
But I think the point is, what does that mean? Like, we don't know what was in the district court's mind. If, in fact, it means the main contributor, don't we need to clarify it and send it back down so the district court can tell us that when he used the term, that's what he understood? Because you may be very well right. I don't want to suggest you're not, that even though the findings are skinny, and I think you would concede they're a little skinny, that they may be enough, and that we could deal with the skinniness by dropping a footnote saying, in the future, you need to show the math more in a more detailed fashion than this. So I get that. But the bigger problem is the one that the chief has been driving home from the very beginning is, what does it mean? What does substantially mean? And what did he think it meant?
And I think the fact that the lower court found that there was infidelity, it was admitted 2007, 2009, and it was admitted that there was another inappropriate affair in 2014.
But he didn't find it was the main contributor, right?
Is it that it seems like I don't remember which brief this was in, but something where the husband testified that was the final straw, that when he heard about the skiing, that was it.
Correct. And he testified to that. He testified that another woman contacted him about that, and he said that was it. The final straw. That's
I thought he
exactly
didn't testify to that because that was cut off on
Yeah.
hearsay grounds.
The text messages were cut off as seriously
But that he
hearsay.
suspected it.
But that he suspected, and that the testimony of him saying he received a phone call from a wife.
Let me try it this way.
So
Was
probably if there had never been any infidelity, that this had been, he never had concerns, completely trusted his wife. If he got this information, that might not have been the final straw. But in the context of it having happened previously, for him it was the final straw.
Correct.
Is that enough under the statute? Is that a problem that since these things from the past kind of came back, and as Justice Simona said, the scab was ripped off and he thinks it's happening again, it could happen again. Is that enough because the final straw wasn't what's considered fault under the statute?
Well, that's a fun question because we're here for the first time in front of the Supreme Court on a fault case. So here we are asking for precedents to decide if this is going to go forward and how it's going to go forward.
Should it be enough?
But let me tell you, this is why the broad impact of this case is going to be so important to the family law community, because this expands Utah family law jurisprudence. This is now going to take another element that the courts are going to have to consider as a factor when you're considering alimony. It goes beyond the Jones v. Jones factors. That's what we've been practicing for the last several years. Or English v. English are the cases that counsel wants to argue and say the court has to find this.
Could you speak to then how we're supposed to balance the fault, which is a permissible consideration, with the economic considerations, which are mandatory considerations? How is the judge awarding alimony supposed to balance those things against each other?
And that's where is that fault's going to come in. That will be the first element. If fault's been alleged, the court will then have to make specific findings of that fault. And if he finds fault, or she, the court then can find the wrongful conduct of one of the parties substantially contributed to the break of the
Let
marriage.
me ask a more precise question. At that point, assume there's a finding of fault, that it substantially contributed, and that's supported by the evidence. Does that mean the judge gets to do anything and everything that he or she wants and completely throw the book at the faulting party, either the payer spouse or the recipient spouse?
No. And I think that if it was a case, say, like Mark v. Mark, where we were up here and we were talking about how he did not award her any alimony. I think it would be an easy decision for the court to say that is an abuse of discretion. We're talking about a case here where Judge Bates gave her a lot of alimony and gave it for a length of marriage that is actually pretty standard for 10 years or half the length.
I'm really still trying to ask you about the legal standard, though, not this case.
Thank you.
And how is the district court supposed to balance these things? And we know that you must take into account a bunch of economic considerations, and you may take into account fault. How do you weigh them and balance them against each other?
I think by doing exactly what the lower court did. Make specific findings, make a finding that falls within the statute of fault.
Okay, so long as you make specific findings, then you can do whatever you want? So for example, Ms. Nelson suggests that there's a floor, that the standard of living is the floor. That is a constraint on the exercise of discretion. Another argument in her brief is not all fault is created equal, and, this was a less egregious form of fault, and that ought to be a constraint on the exercise of discretion. Could you speak to those two things?
So it has to fall within the confines of the statute. The legislation intent was exactly what it says, and I don't think there's ambiguity to the statute. I think as long as it falls within, the court has the ability to, and I think it's important. The statute says may. It doesn't say must. So when we talk about the whole punitive or punishment issue that comes in along with this, finding of fault now allows punitive or punishment. That's it. That's what the statute is to do.
Let me give you a hypothetical. Let's say it's the payor spouse that has perpetrated the fault, that substantially contributed to the dissolution of the marriage. And the district judge says, I'm so angry at you, I'm going to require you to pay every single penny that you earn over to alimony. Is that permissible?
Yes, if within the confines of the statute, because we actually have case law, a couple cases that fall right into that, where
And no matter how egregious the fault, because the things that are listed in the statute by way of fault, I mean, they run a wide range from, really, really difficult problems of physical abuse, to other things. And so no matter how egregious the fault, as soon as the judge finds fault, the judge just can require every penny that the payor spouse earns to be paid over by way of alimony. Is that your position?
My position is it has to be within the confines of the statute, and it's their discretion. We have very smart...
When you say confines of the statute, what do you mean?
I mean that the statute specifically says that the court may order or withhold alimony and adjust the amount, which would be in your scenario because he can up it or lower it, and the term of any alimony order. He can do that within that confine if he finds fault under the statute. And
Yeah, I mean, I have trouble with that as well. That is just basically license to a judge, as long as he makes findings, and as long as it really was, let's say, infidelity, to do what he or she wants. That there seems to be, as long as you establish those predicate requirements, the judge is, anything is within the judge's discretion. And if it is cabinets, is that your argument, first of all?
within his discretion within the confines of the statute.
Well, yeah, the confines of the statute are, there was infidelity, and he made findings on each of the required elements. And now at that point, is there any restriction on the scope of the punishment that the judge might mete out?
I see your question, and my answer is yes. I mean, there's got to be some restriction.
Okay, good. So let's articulate it.
Okay.
Let's figure out our standard here.
How about equity?
Sorry, what?
Equity.
Equity.
It seems that in family law cases, courts are always called upon to make equitable decisions. It's one of those areas where courts do this. They have to decide what's fair. Now, in some instances, no. The child support guidelines, there are specific numbers that a court has to follow. But does equity and fairness give us some parameters here? It seems to me that you have the mandatory alimony factors that a judge has to consider. many cases there's no alimony at all, but a judge is supposed to consider those factors. The legislature has pointed out a few specific things that go beyond the usual complaints that people who are divorcing might have about each other. If you got into a discussion about who caused the divorce, normally that's not going to get you anywhere good in a divorce trial, but the legislature has spelled out sexual affair with someone else, physical abuse, these other things where they're saying these cross the line. If someone has crossed the line in these ways that we have laid out, that can be an additional factor to consider with the other alimony factors, and the judge always has to be bounded by fairness. What are your thoughts on that?
I think most people that pay alimony would never think that it's fair and or equitable. And in fact, I think that's a big confusion is people believe alimony is equitable. However, we're an equitable state when dividing property. Alimony has a different standard of looking at the Jones v. Jones standard or looking at what the need and the ability to work. So we look at that standard for alimony. So when we're looking at this case, the fault statute does not give the ability to make an unequitable divide of property. But we have in the statute that you can do an unequitable divide if you find that there's some substantial reason.
Okay, so that's an argument that the standard is not, at the end of the day, the judge asks whether it's fair. That's your position, right? That's right, correct?
It's never fair.
That's your position. Okay. Well, no, I'm not sure about that. Maybe
Well,
from the party's perspective.
Nobody ever wins, I guess, is the
Okay,
better.
but so if you reject that standard, that there's a fairness overlay after all the I's have been dotted and T's crossed, right? How about an egregiously unfair overlay well, yeah, let's go with that. Egregiously unfair. And we've had some case law suggesting that maybe that question should be introduced into the analysis.
And I agree, and that's the appellate case law that we have. Mark v. Mark is a perfect example of, was it fair? Appellate court said no and remanded it. You know, 27-year marriage, he got 1 year, he's had rarely worked during the marriage, and he got 1 year of alimony. The court said that was not enough time for rehabilitative or to get him to close the gap.
Okay, so you'd acknowledge, then I take it, correct me if I'm wrong, that at the end of the analysis, the final question for us to ask is this egregiously unfair?
Correct. And I believe that's where, because the court has the discretion to make the findings that they did. And our position is that this was not unfair. She's receiving $2,000 in alimony. She's receiving it for 10 years. And then once the last child emancipates, she gets more alimony. So she's not slashing. And one of the things that's about this case is they've talked about alimony so much that child support has been forgotten. And when we look at family law cases, as a family law attorney, we look at family support. So we look at them in tandem. We don't piece it out and say, oh, she's only receiving this much alimony, so she's only receiving this percentage.
Could I ask you this? What's the non-arbitrary basis for the following things? One, you don't need to live in Olympus Cove. Go live on the west side of the freeway. Mm-hmm. Two, you don't need to drive this nice of a car. Drive a less nice car. Three, I'm going to impute full-time income to you despite evidence that you may have a disability. What's the basis for those determinations?
So I'm glad you asked that, because that goes straight to the facts. And what happened is she moved into a very expensive home in Olympus Cove when they still had the marital home available to her. She created, during the pendency of this divorce, 2 ginormous house payments that the parties couldn't afford. When we got to trial, she said, I'm staying here. It was only on the day of trial that we found out that she was not paying for the house. Her dad owned it, and her dad was paying for it.
Did he detail these in his findings?
He did not. It's in the transcript. So that was the evidence that was presented.
So is that enough of a basis for a determination by the court that you don't need to live in Olympus Cove?
It would have been a basis if he did it on an analysis of need, and we were just going through the Jones v. Jones standard. I would have been harping on that. She doesn't have a house payment. It's not reasonable and necessary. And that's where we would have gone with that. What he is stating, though, is that he was going to allow her to meet her need, but he was going to lower the standard of living. So he moved her from a $2,500 home to $1,600.
Because he was offended by her sexual affairs.
Well, I wouldn't say that. I say that within the confines of the statute, he found that that was what substantially contributed to the breakup of the marriage, and therefore he lowered her
I mean,
standard.
I get that finding, and I think on that point, I mean, I want to think some more about this, but you may be right. There may be a basis for deference to that finding. Where I get tripped up on your side of the case is just how much discretion then do we give to the judge to make adjustments to alimony, and is there enough of a basis for the adjustments the judge made to the alimony on the basis of that finding of fault?
And if I can address that. So another thing about the car. She didn't have a car payment. She had a paid-off car, a really a capable car. But she testified that she wanted a new car or a new...
She testified that she was afraid it was about to break down.
Correct. But what I'm suggesting is she did not have a car payment. She came into court and said, I would like this car. Please allow alimony to go up so I can buy this car. So when the judge gave her $250 for a car, it technically wasn't an expense that was proven, which we have analyzed in Dahl v. Dahl. So he gave her money when she actually didn't have the expense. And that's where the reason why I believe that the court can affirm this decision is because he didn't abuse his discretion in making a finding of fault and then lowering her standard of living.
I want to take you back to that. What finding of fault? I mean, I may be really inarticulate about this, but this is the first time this type of case has come to us, right? And we're going to have to say something about what substantially contributed means, right? We're going to have to put some words to that skeleton. Like you said, maybe the major reason, whatever that is. We have no idea on this record what the trial judge was thinking when he used that term and made that finding. He doesn't tell us how he understood the term substantially contributed. He doesn't tell us whether he thought that was 10%, more than 50%, 100%. When we put the flesh to this skeleton, we're not going to know if he had the same definition of substantially contributed in mind that we're putting on now, because he never told us.
Right.
So how do we not send it back down?
And my argument, first of all, let's make it simple. Stay within the confines of the statute. Which,
No, but we still have to define what substantially contributed to means under this fault provision of
Okay.
30-3-58, right?
right. The statute says engaging in sexual relations with a person other than the party's spouse.
Yeah, no, so we find and make that factual finding. But then we have to find that sexual activity, quote unquote, substantially contributed to the breakup of the marriage. And we're going to have to put words to what substantially contributed means. The trial judge never said, I'm interpreting this language as X. This is what I understand substantially contributed to means. We may very well be issuing a decision that has completely different meaning than what he had in mind. And I'm just saying, under this scenario, given that it's the first time that we've had this type of case, that we're going to articulate for the first time what that term means under the statute, how do we not send it back so that we can make sure we're on the same page?
Well, let's talk about two findings he did make. We know what he didn't believe substantially contributed, which is paragraph 47, which he said that the mutual verbal abuse and the single act of physical abuse did not substantially.
Would you give me that it could be that he thought substantially contributed was 10% of the cause?
At the paragraph 48, he says.
He just doesn't tell us.
Right. But my thing is he had the discretion, it was methodical, and he says in paragraph 48,
Absolutely.
based on the evidence before the court and lack of any other reasonable explanation as to why the parties' marriage fell apart, the court finds that Ms. Gardner's sexual relationships caused the breakup of the marriage.
I mean, isn't that part of the problem, though? The lack of any other reasonable, I mean, there are other explanations, and doesn't that just sort of underscore Justice Simonis's concern, which is, we know there were other explanations. What we don't know is what percentage of causation that the judge may have attributed to those other considerations versus the sexual affair.
Right. And my only answer is, again, first case of precedent, this is going to kind of lead, this is monumental. We understand that. But and I'm in the family law community, so this is going to be the case that we talk about in the future. Unlike my client doesn't love that, but that's just what it's going to be. But my thing is that the statute was defined. That's exactly what we wanted. That's what the court wanted to do. And the lower court made his findings within the confines of that statute. It's his discretion. And the statute specifically says may. So I agree with your concern about what substantially contributed. But my fear is if the court remands it, or if the court says that this wasn't fault, we're now opening the window to say, well, then maybe we shouldn't be a fault state.
Well, do we really? I think Justice Simonis makes a strong point here, and because it is a significant case, because it is the first case, it's our first opportunity to give some meat to the bone of substantially caused. And so it's not enough to just say, well, within the confines of the statute, she committed adultery, therefore virtually unfettered discretion. Okay, because I think you would acknowledge that not all adultery, let's say, infidelity, would necessarily substantially contribute, however defined, right?
Correct.
So there are two kinds of infidelity, those that substantially contribute and those that don't. Well, to decide between them, substantially cause, it offers just a wide range of potential definitions.
Yeah.
Everything from main cause, which I would imagine Ms. Nelson would fully endorse, maybe not, but it seems like it would be a pretty good standard
Right.
for her. Everything from that to contributed in some significant measure, or was a factor, or, it's a whole range. And so, I like Justice Simonis, I struggle with how we can, without defining that, or if in the event we do define it, one thing we cannot know, because it's, as Justice Simonis puts it, the district court judge did not show his work. We cannot know what his definition was. Whatever the right definition of substantial cause is, that's something we don't have the record to get at, right?
Well,
And so he could have decided under the completely wrong standard, the wrong standard as we now will articulate it.
Right.
I mean, that's no criticism of him at all.
Right.
He doesn't have much guidance in this respect. It's just the point is we don't know the standard to use.
Right. And as you guys know, family law, most of you have been on the bench and did district court family law cases. You can have the same set of facts and come into court and have completely different results. There is not one like the other.
Exactly. But we still always need standards, right? For people to argue their cases too.
Right. And the standard, and what I believe, is that we just now expand the family law jurisprudence to state that there's now additional factor when determining alimony. If it's found, the judge's discretion based off of the facts, based off of the situation, is going to be able to then make those methodical facts. I think the lower court, he knew. He knew that this was going to be a case probably that he hasn't done before, or that this was going to be monumental in case law. And he did the best he could with what he had. So when we kind of pin it to say he needed to make these specific findings, I would say, yes, we're here. Let's make maybe that. But you're never going to get a case like this.
I'm not trying to be critical, because I understand the role the district court was in. We haven't said what substantially caused or contributed to means. But we don't know what he was thinking. We don't know how he defined the term. He didn't say, I'm interpreting in accordance with how the court has interpreted substantial in these other cases. We have to, in this case, announce a standard. I don't see how we take this case and not. And you may end up in the same place, but I'm really struggling to see how we don't remand it to make sure we're singing from the same page of the hymnal in terms of what we all understand substantially contributed to mean.
And whether we need remand it substantially contribute, or we just define it with the argument. Because I think the standard was there, I think the discretion was there, and I think he made the right decision. I want to just use one analogy, if you would let me, is that look at the domestic violence part of fault. If you look at that standard, liken it to this. Somebody commits domestic violence in 2007. There's a police report. Maybe he went to jail. 2009, there's another domestic violence act, but they stay together. Then in 2014, he gets angry again, and he goes to hit her, but this time she runs out the house, and she decides to file for divorce. I think we have to be very, very careful in making a time frame or saying that one doesn't cause the other, because we're looking at cases like that, where, like you said, we're going to have to wait till they have an affair, or we're going to have to run to the courthouse. We're going to have to file divorce because I don't want to pay alimony to somebody that's been unfaithful to me. Or another injured spouse that says, I want more alimony because he cheated on me. Any other questions? I just asked the court to affirm the lower court's rule.
Thank you, Ms. Coyle. Ms. Nelson?
Ms. Nelson, what does substantially contributed or
Well,
substantially caused?
I heartily endorse her suggestion that it means the main cause. That sounds good to me. And I think it's also important to talk about whether it's the main cause.
Less tongue-in-cheek, though. Do you have authority for how we should interpret the term substantial or substantially?
I think it should be very significant. I think it should be very significant. And I think it should be very significant for both parties. Where you have one party who's upset about it and the other party who, this is not a factor. The reason I'm getting out of the marriage is because I'm unhappy with you. I think that matters.
So it's very significant, not significant, but more than significant. Is that?
Yes,
is
much
that
more than 50%. Much
the-
more than 50%. I would say up in the 80% range.
I mean, we're never going to be able to put numbers.
No,
on
we're
this,
not.
Right? I mean, this is just, when we talk about causation, we can talk about but for, we can talk about
Proximate cause, right?
Isn't the best we're going to be able to do just to use adjectives that admittedly have some fuzziness to them?
I think so.
And to say, well, it's X percent, I mean, that we're never going to be able to do that, are we?
No, I don't think
And
so.
if we can't, then why? I mean, I understand the pushback and the concern about possibly the need for a remand, but if the most we're going to be able to do is come up with a synonym of substantial, like significant, why do we need to remand? Because isn't the legislation just conceding to the point that you're not going to be able to have a numerically precise adjective, and you're just going to be left with, well, it has to be significant or substantial? And if so, Judge Bates made his finding, and either it gets deference or it doesn't.
Well, my position is that you don't need to you do need to remand. Well, let me back up. My position is that his view that the 2007-2009 affair substantially contributed to the breakup of the marriage is not supported by the evidence.
Well,
and we haven't talked at all about the phrase the breakup of the marriage. Are we talking about the day the divorce papers get filed? Or are we talking about the separation? Because it didn't substantially contribute to the
I
separation.
want to go back to this discussion, though, because I don't think we just say, well, the legislature said substantially contributed and we leave it at that. I mean, I think that we can say, well, substantially contributed means the primary mover or the most significant mover. There are all kinds of ways, and we do it all the time, where we put meat to the skeleton. I get a little tongue-in-cheek when I'm talking about the percentages, because I totally agree with Justice Lee. We're not going to say, court, you have to find it's 50% or 80% responsible. But I think that there are ways that we can use the English language to help announce a standard that's workable for the district courts.
Well, I would use proximate cause if that were my choice. I mean, if we're going for tort analysis, then I would want something that was that tightly tied to it. I mean, I've considered how tort analysis might fit in here, and it introduces some other problems. So I haven't adopted it wholeheartedly, but that would be a place to look to, as Justice Durant said.
Is that the language of proximate cause, substantially contributed?
Well, no, the language is proximate cause. I guess I agree with you that we're swapping adjectives around and we're trying to decide where to pin it. The legislature's chosen substantially contributed.
Sometimes we look at legislation and we say, well, this is a legal term of art. It's borrowed from a field of law. You know, let's look to that law to flesh it out. Right. Are you aware of any fields of law that use the terminology of substantially contributed that we could look to? That might
No, I actually did a Westlaw search for that, and the only places I could come up with it were in sentencing And I think I actually cited that in my brief, a couple of places where it was used, but it's very fuzzy.
So we
It
have,
seems like
okay.
we should just go to the ordinary meaning. I don't have a dictionary in front of me, but what about just the meaning of substantially? Whatever a dictionary tells us is the ordinary meaning. Why can't we just use that?
Well, maybe we will, but I think that we still are saying, so is it was in the background of this conversation that these people were having? Because to me, that's what was happening here. It was in the background, but it was not the driving force. In the divorce, it wasn't the driving force in the separation, and it wasn't the driving force of the divorce. And it seems like what the legislature is getting at is something that was a driving force in these parties actually separating.
By selecting out 4 things, is the legislature kind of creating a presumption that if one of those things happens, it is a pretty significant reason? If your partner is physically violent to you, if your partner cheats on you with someone else, that's probably, unless you have a unique marriage, open marriage or something, that it's probably going to be a big deal, and it's going to be a reason that the marriage breaks up.
I think that that's what the legislature is saying, but the open marriage does create an interesting problem, right? What if they have an open marriage, but then when they get divorced, they're like, you cheated on me, right? I mean, I can see that becoming a problem in a different case. I do think another aspect of the legislature defining those 4 things is this. The legislature has said there's 4 things that are a problem, but they've said there's only 4 things that can be considered. And to me, that confirms that fault should not be able to override all of the other factors, that the judge doesn't have discretion. So if there's something that's really bad but isn't covered by the statute, like, for example, you killed my mother, that's not part of the statute, actually, but really bad. So we're not going to allow them to consider that at all. But if you had an affair 10 years ago, then we're going to allow the trial court to consider that 100% over everything else. To me, there's significant cognitive dissonance there. I think it just confirms that those 4 things can be considered, but they're only a small thing. They don't override everything else. And that gets me back to this idea that we're in a narrow range and fault has a minimal impact. And maybe Justice Lee is right that we need a sliding scale. The worse the fault, then the bigger impact it can have. And I just would point to... I need to grab it. Sorry. Judge Orm, in his concurrence and dissent in 2009, Mark versus Mark, he offers a suggestion that doesn't address all of these things, but I think it's helpful. He says procedurally, to ensure that the role of fault can be understood by the parties and appropriately reviewed on appeal, the trial court in a given case should first come to an alimony award based just on the usual criteria, and he cites the statute. And then he says, if it determines that one party's fault should lower or increase the amount of the award, it should identify the precise character of the fault in question, the relevance of that fault to the matter of alimony, and the amount by which alimony should be increased or decreased by reason thereof. And that may be the best that we can do. May I make just a couple of more points in response to her argument? Just briefly, that she's offered
If you could be very brief.
Very briefly, she's offered some alternative explanations for why the trial court may have done what it did, but it was very clear in findings 11 and 13. I'm looking at the same document, Justice Lee, is very clear that the reason it was lowering her housing and her car was because of her fault, not for any other reason. And we're definitely tied to those findings.
At any point in the record, did the trial court tell us that he was applying a plain language meaning to substantially contributed?
That's not coming to my mind.
Okay.
If there are no further questions, we ask the court to reverse. Thank you.
Thank you. We very much appreciate argument from all counsel. It's an important case. We will take it under advisement. Court is now in recess.